Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Sunday. Man, oh man, Ashevitz, I am glad you're here, and I think you will be by the time we're done. We have two great guests, Senator Tom Cotton and Ryan Morrow of the Capital Research Center. Boy, does he have some information to reveal this evening. But are you ready to have a little bit of fun as we go down history lane a little bit and actually apply some facts to our opinions? I have some of the books here that the framers of your Constitution found extremely influential. And you know what's interesting as I read these books over the years and many more, not a single one of the framers of our Constitution and not a single one of the great thinkers, philosophers, scholars that they cite supported government by judiciary. Do you know what we have in the United States today? A post-constitutional government by judiciary. That's what we have. That makes it a judicial tyranny. Because no less than Montesquieu, who was very, very important to the framers of the Constitution, three branches of government, and you know the three, he made the point that should one or the other of the branches combine, you have tyranny. Right here. Very influentially cited in the Federalist Papers. There were others. How do we know these people were cited? Number one, they said so. Number two, Jefferson even listed them. Algernon Sidney. Ever hear of Algernon Sidney? Well, Jefferson did, and so did the others. Discourses. Brilliant, brilliant book. Really the only brilliant book he ever wrote, but, I mean, that's plenty of book, I would say. Here we have the Federalist Papers. Very, very helpful, because that's exactly what they were thinking when they were trying to get the Constitution ratified by the states. Here we have Cicero. Cicero was a brilliant man. He influenced the framers of your Constitution. So did Aristotle, in a very significant way. So there you have Athens, and there you have Rome, and they looked at those. Of course, John Locke, very, very important during the Revolutionary period. The whole idea of natural law, nature's God, right reason, which you get from God and which is provided to us from the Judeo-Christian value system. He was on top of it. He was fantastic. And here we have not only the Federalist Papers, the Anti-Federalist Papers, we have letters and articles over the struggle over the Constitution, right here. Two wonderful volumes, and much, much more. Now, why am I getting into this with you? Because America today has no resemblance whatsoever to what any of those men wrote, to the influences they had on those who wrote and promoted and fought for the Declaration of Independence and the Constitutional Convention. You all have people come on TV as legal analysts. You all have people write their pieces on this website or that site going about, you got to follow the orders of the court. That's outrageous, and so forth and so on. Well, shouldn't we first find out what the Constitution says about the courts? This is very important. Judges were never supposed to be policymakers, and they were never supposed to second-guess the executive or legislative branches on policy. They had a lane, and they were supposed to stay in the lane. It was a great book written by Raoul Berger. Raoul Berger was a great professor. He was not a lawyer. He was a great constitutional historian, one of the greatest. And he wrote a book, Government by Judiciary. And among other things, he reminds us, the most significant single piece of evidence that the framers excluded the judiciary from policymaking was the rejection of the participation in what they called a council of revision of legislation. Now, what in the world is that? Well, it came up prominently at the Constitutional Convention. Virginia's Edmund Randolph, who had a lot of power at that convention, he would later become governor of Virginia, he proposed in the convention that the president, quote, and a convenient number of the national judiciary ought to compose a council of revision, unquote, to examine every act of Congress and by its dissent to constitute a veto. And by act of Congress, they also meant whatever this president they were thinking about who hadn't been created yet, the executive, him too. Now, James Wilson, another very prominent founder from Pennsylvania, a delegate, he would become a justice of the Supreme Court, and later he was broke and he owed debt, so he went to debtor's prison, just as a side point, but he's a brilliant man. He wrote, laws may be unjust, may be unwise, may be dangerous, may be destructive, and yet be not so unconstitutional as justify the judges in refusing to give them effect. Let them have a share in the revisionary power in order to counterattack the improper views of the legislature. In other words, he says, judges, you have a lane, and your so-called judicial review is about who has power, but it's not about making decisions about fine points of public policy, despite the fact that the proposal had the support of James Madison. These are some very powerful delegates, and therefore, perhaps the most influential trio in the convention, it was rejected overwhelmingly for reasons that unmistakably spell out the exclusion of the judiciary from even a share of policymaking. Nathaniel Gorham, one of the delegates, saw no advantage of employing the judges in this way. As judges, they are not to be presumed to possess any peculiar knowledge of the mere policy of public measures. Elbridge Gerry, one of the most vigorous advocates of judicial review, he opposed judicial participation in the council vehemently. Charles Pinckney also, quote, opposed the interference of the judges in the legislative business. How do we know all this? Because Madison took copious notes. They're called Madison's notes. Rufus King joined in the opposition on the ground that, as the judges must interpret the laws, they ought not to be legislators. Roger Sherman, quote, disapproved of judges meddling in politics and parties. It is reasonable to infer that John Dickinson, this is him writing, delegate from Pennsylvania, Dickinson, you may have heard of the college, expressed a widely shared view in cautioning that judiciary of Oregon became by degrees the lawgivers. Plainly, the framers refused to make the judiciary lawgivers, even to the extent of allowing them to share in the legislative making of the law. They said no, let alone finally to decide on the policy, an exclusive legislative function. That is, you in the courts, even you in the Supreme Court, you don't get to make the final decision on policy. They drew a line between the judicial reviewing function, that is, policing grants of power, to ensure that there would be no encroachments beyond the grants, in other words, to make sure the three branches stayed in their lanes, and legislative policy making within those bounds. No, court, you don't get to go into the legislating policy making into the executive branch. That's none of your damn business. Dangerous and destructive as such policies may be, quote unquote, they were yet to be the exclusive province of the legislature and eventually the executive when they created it. That is the inescapable inference from the facts and fortified by other historical information as well. I mean, all over the place throughout history, what the courts are doing today is tyrannical by any definition of the word. It's anti-constitutional and thus unconstitutional. So when you have former federal prosecutors and others on other channels and so forth getting up and saying, the president's defying an order. He is, or he's not. But they don't ask the first question. Where did the court get this authority in the first place? Well, they got it from Congress, who wrote the law. That's not what the framers thought. Congress doesn't have the power to do this either. They can write a law, but they have to stay in their lane. They have to stay in their lane too. Congress isn't a legislative branch created by the framers that's free to get involved in anything and anything they want, and just because they pass a law, they can encroach the executive branch's authority and so forth and so on. I'm getting back to the text of the Constitution, to what the framers wrote, not what has transpired today. So I wanted to point that out. Now, birthright citizenship is back. I've discussed this, 412 times over the course of the years I've been here. For 20 years on radio, I've written about it, and yet we still have reporters who don't know what they're talking about, either by ignorance or on purpose. One reporter the other day said, birthright citizenship is in the Constitution, the 14th Amendment. No, it's not. Not in the least. It never has been. Our friend Hans von Spakovsky over at the Heritage Foundation, he's pointed out, as I've pointed out, as so many others have pointed out, he says, what's the citizenship status of children of illegal aliens? What is it? Well, no court has ever ruled that they're citizens. No court. He goes on, the 14th Amendment. Critics claim that anyone born in the United States is automatically a U.S. citizen, even if their parents are here illegally, but it ignores the text and legislative history of the 14th Amendment, which was ratified in 1868 to extend citizenship to freed slaves and their children. The 14th Amendment doesn't say that all persons born in the United States are citizens. I think that if that's what Congress meant, and if that's what the ratifiers meant, they would have said that. They never said that. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof. You don't subject yourself to the jurisdiction of the United States by walking into the United States as a non-citizen saying, I'm here. That's not how it works. That sentence is critical. Conditional phrase. It's conveniently ignored or misrepresented by advocates of birthright citizenship. Critics erroneously believe that anyone present in the United States has subjected himself to the jurisdiction of the United States, would extend citizenship to the children of tourists and diplomats and illegal aliens alike. That's not what they did in 1868. There is absolutely not a word anywhere in any document, in any transcript, that even crossed their minds. It was so preposterous. That's not what that qualifying phrase means, the jurisdiction thereof. Its original meaning refers to the political allegiance of an individual and the jurisdiction that a foreign government has over the individual, not the legal jurisdiction, because you can have foreigners in the country who violate the law and you prosecute them. Does that make them citizens? No. The fact that a tourist or illegal alien is subject to our laws and our courts if they violate our laws does not place them within the political jurisdiction of the United States, as the phrase was defined by the framers of the 14th Amendment. The amendment's language was derived from the 1866 Civil Rights Act, which provided that all persons born in the United States and not subject to any foreign power would be considered citizens. Senator Lyman Trumbull, a key figure in the adoption of the 14th Amendment, said that, quote, subject to the jurisdiction of the United States included not owing allegiance to any other country. Now, you have to have absolute allegiance to the United States, one political entity, the United States, and that's that. Even in a case called U.S. versus Wong Kim Ark, which all the birthright citizenship acolytes repeat. It was 1898. It was a case, it's often cited by the birthright supporters. Due to its overbroad language, the court only held that a child born of lawful permanent residence was a U.S. citizen. That's a far cry from saying that a child born of individuals who are illegally must be considered a U.S. citizen. But even in that case, that's not what the Constitution says. So the United States Supreme Court today is free to reject this 1898 decision, but certainly it can't argue that there's precedent for illegal aliens, that is, their children, having birthright citizenship, because no Supreme Court has ruled that. The State Department has erroneously interpreted that statute, a statute 18 U.S.C. section 1401, to confer citizenship on illegal alien children. So this was done by a bureaucracy. This was done by a fiat. It was never done by federal law. The federal law doesn't help the birthright citizenship crowd, because Congress never conferred birthright citizenship on the children of an illegal alien. Never. And so the problem is the Supreme Court has a Chief Justice who looks at the pages of the New York Times as much as he looks at the pages of the Constitution, and an Associate Chief Justice in Barnett who does the same thing. I mean, maybe they can say everybody's grandfathered in, and from this point forward or a certain point forward, we're actually going to uphold the Constitution and so forth. I don't know. We'll see. Next issue. I'm on the move. Harvard University, or maybe it's called Harvard College, they say we have an absolute right to discriminate against Jews and discriminate against anybody else. Anti-Semitism is flourishing. DEI is flourishing, which is racist in every respect. It's backdoor affirmative action. And so we consider this to be academic freedom. And I wanted you to know something about Harvard. Harvard has a long history of Jew hatred. Now, this may come as a surprise to you and to many Jews who attend Harvard. But I want you to listen to this. We've talked about this somewhat before. The David S. Wyman Institute for Holocaust Studies. Stephen Norwood, professor of history and Judaic studies at the University of Oklahoma. The Harvard University administration during the 1930s, led by President James Conant, ignored numerous opportunities to take a principled stand against the Hitler regime and the anti-Semitic outrages it perpetrated, and contributed to Nazi Germany's efforts to improve its image in the West. The administration's lack of concern about Nazi anti-Semitism was shared by many influential Harvard alumni and students. A faculty panel that supervised a mock trial of Hitler in 1934 ruled that Hitler's anti-Jewish actions were irrelevant to the debate. Nazi leaders were warmly welcomed to the Harvard campus and invited to prestigious social events as the Harvard administration strove to build friendly relations with thoroughly Nazified universities in Germany. And by doing so, Harvard's administration and many of its student leaders offered important encouragement to the Hitler regime as it intensified its persecution of the Jews and strengthened its armed forces. Wow. Well, the modern day Nazis, you know, Hamas, Islamic Jihad, Qatar, countries and individuals and groups like that. Harvard has a liking to them, too. They're not the only ones, of course. There's Princeton and Yale, the Ivy Leagues, you know. President Condit's insistence on treating Nazi academics as part of the learned world and his reluctance to offer faculty positions to prominent Jewish refugee scholars was shaped in part by his own anti-Semitic prejudices. When the DuPont Corporation sought his advice about hiring a German Jewish scientist who had fled the Nazis, President Condit urged it not to employ him, noting that he was, quote, very definitely of the Jewish type. Very heavy. Goes on and on and on. Harvard has a long and storied history of playing footsie with Hitler and the Nazis and so forth and so on. It's incredible. And I want to end my opening statement tonight with one more issue. We have a person by the name of Garcia. The Democrats have taken a liking to Garcia. Garcia, they say his home is in Maryland, when obviously under federal immigration law, I thought they believed in following the law. His home is in El Salvador. He came to the United States illegally over and over and over again, but he was welcomed apparently in the state of Maryland. And got a home there, and he beat the hell out of his wife. Excuse me? He's a wife beater. Right here. I want to thank Bill Maloogian and Fox. Somehow the New York Times and the Washington Post missed it. Somehow CNN and MSNBC, NBC, ABC, and CBS missed it. Somehow AP and Reuters missed it. Somehow the Democrats in Congress missed it, but they don't much care. That's right. This is a public record. With all the billions spent on media around this country, and all the opposition research and other research done, it was left to Fox and Bill Maloogian. And this is in her own handwriting, ladies and gentlemen. Sentence after sentence about her beloved husband, the Marylander, beat the crap out of her on more than one occasion. And so there we have Chris Van Hollen, who attacks the Jews in Israel, who attacks Netanyahu. There he is in El Salvador. What is he doing in El Salvador? Thanking them for taking criminals off our streets? No, he wants to meet with Mr. Garcia. He meets with him. They have a nice drink. They have lunch. He's very concerned about him, puts his arm around him. So I think it can finally be said that the Democrat Party not only doesn't give a damn about hundreds of thousands of women who've been sold into sex slavery thanks to their border policies, or 325,000 unaccompanied minors who are still unaccounted for as this administration is desperately trying to find them. They care about Mr. Garcia, a wife beater, an MS-13 member. They say not. Courts say yes. Who are we to believe? The media that lied about Biden and everything else? No, we don't believe them. So they have their new superstar, their new symbol, Mr. Garcia, wife beater. Wow. I didn't think the Democrat Party would sink that low, but then again, it's the Democrat Party of a lot of reprobates, malcontents, and miscreants.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.